as the chair, maybe I would like to suggest that we're going to start. Would somebody like to close the door just, or I mean, maybe people want to join in, or fine, that's great. Can everybody hear me? Okay, yeah. Okay. Okay.
Could you put the mic closer to you?
Yes, sorry. Is that okay?
Yeah.
Okay. I hope everyone has had a good lunch and is well rested now to start this session. My name is Stefanie, and I'm very, very happy to be here and very happy to be in Israel. So I'm not sure if any of the organizing members are here or committees here. So thank you very much to those guys who've been working very diligently to get us all over and to organize this conference. First, I'm going to briefly introduce the session, and then I'm going to briefly introduce the speakers. We just decided that we're going to listen to all 4 presentations, and then take questions, and that's the way that we're going to proceed. So this session is titled "Early Modern Political Struggles," which I think is quite aptly, as it reflects on some of the religious and political conflicts that we can see throughout the medieval times and the late medieval times, which I think is all the sort of time that you structured your presentations around. The first speaker is going to be Kacper. Sorry. And Kacper is from the University of Kraków, and he will be talking about the role of the Starost, which I understand is some sort of official or unofficial position of leadership, authority, senior leader in the judicial system of the Kingdom of Poland in the 17th century. So I'm going to open the floor to you, and you will have 15 minutes. Thank you very much. Okay.
So, the microphone.
Oh, sorry.
I'm going to use it, I suppose.
I'm going to take that there.
So, hello everyone. In my presentation, I would like to discuss the role of Starost. It was something like local governor of the king in the modern Poland, and the role of Starost in Polish judicial system at the turn of 16th and 17th centuries, as it was quite wide sphere. I would like to limit it only to the participation of Starost in the homicide trials. I think it would be much more interesting than discussing all these issues considering administration or taxes. So in the first part of my presentation, of my speech, I would like to briefly discuss the problem of homicide in Old Polish law, mainly discussing the problem of punishment of homicide. And then I would like to present a role of Starost in the homicide trial in particular aspects. So as we know, homicide is one of the oldest crimes committed through the history, or even the prehistory. Despite the diversity of cultures and civilizations, it occurred all around the world. And although it was such widespread felony, its legal interpretations or even punishment happened to differ. If it comes to punishment in Old Polish law, there existed 2 pillars in penal system of homicide punishment. So there existed a public punishment, so pena publica, as well as the compensation. So pena capitis, in Polish it was główczyzna. The pena capitis, so the compensation, was older. It existed even before the statutes of Kacper the Great. That was a codification of Old Polish law from the mid-14th century. And this, before the statutes partially regulated the Polish legal system. Generally, the Polish medieval compensation was a sum of money paid to the deceased relatives so as to either satisfy them or even more to evade their vengeance upon the murderer. Such satisfaction was a means of avoiding legally approved revenge. Thus, the revenge custom disappeared. The compensation was still present in the Polish penal system in modern period. Although it was fixed in the Casimir the Great statutes at 60 markas, that was an amount of money, and Polish marka was named grzywna or hrivna, from the Ukrainian currency. It was later raised several times. At the turn of 15th and 16th centuries, it was fixed at 120 markas, then in 1588 at 240 markas. Using the firearm in order to kill each other was specially tolerated, so in 1550 the compensation was doubled if the perpetrator of homicide was armed with any kind of gun. The compensation could be claimed either in criminal or civil lawsuit. In 16th century legislation, it is noticeable that claiming satisfaction of homicide happens to be treated, mostly theoretically, separately vis-à-vis the criminal suit. So contrary to public penalties, the possibility of claim was limited by the prescription. So the compensation could not be claimed after 3 years had passed, since, of course, the committing the homicide. If it comes to the death penalty, here is the amounts of compensation. If it comes to public punishment, apart from the arbitrary death penalty known in Middle Ages, there was an imprisonment that was the basic punishment imposed on killers. It was instituted in the end of 15th century in the constitutions of 1493 and 1496, and defined as penaturis or pena carceris, so the penalty of tower. In principle, it was fixed at 1 year and 6 weeks. However, the firearmed murderer had to spend 2 years and 12 weeks in the tower. The imprisoned was obliged to serve the time in fundo, so in the bottom of the tower. In fact, the poor conditions of the depth of tower often caused serious diseases of imprisoned, sometimes even deaths. So as a result, the tower imprisonment was commonly regarded as de facto capital punishment. In Polish legislation, you could find particular types of homicide that led to the death penalty. First of the aforementioned cases was when homicide was committed in conventionibus. So during noblemen's assemblies like Sejm, so the Polish Parliament, the General Assembly, or Sejmik, so local assembly of noblemen. Similar provisions were enacted in the mid-16th century when instituted the death penalty for homicide during cards, or in 1578 the capital punishment for killing a noble during Crown Tribunal session. Since the beginning of 17th century, the murderer that committed such crime using firearms or a bow should have not only been sentenced to death, but pronounced infamous as well. And also since the end of 15th century, killing a noble or a member of his family, also his servants, during house assault also led to the death penalty. Since the end of the 16th century, the perpetrator of intentional homicide with firearms was sentenced to a perpetual banishment. If it comes to statutes of Casimir the Great from the mid-14th century, it described also a particular qualified type of homicide, so the parricide, killing of a member of family. The perpetrator should have been pronounced infamous and was deprived of succession after the deceased. So, To sum up, at the turn of 16th and 17th centuries, the basic punishment for the homicide in Old Polish law were the imprisonment, so pena turis or pena carceris, for 1 year and 6 weeks, and the compensation for deceased relatives. If the killer had used firearms, the penalty was doubled. If it comes to death penalty, it was decreed mostly when the crime was committed during public assemblies, during house assault, or by arbitrary decision of a court. And I would like to move to the Starost jurisdiction. This is the first part of Starost participation in the homicide trial. So in principle, the court that had competence at compensation adjudication was the Judicium terrestri. So something like terrestrial court composed of deputies of nobles, deputies that were nobles. After the imprisonment, penalty was introduced. At the end of 15th century, it was the royal court. Later, it was the royal court during the same that had jurisdiction over homicides. If it comes to the jurisdiction of Starost court, in the beginning of 16th century, it was an extraordinary situation. The limitation of Starost jurisdiction over gentry was a permanent demand made by noblemen. So since 15th century, Starost could only adjudicate in 4 cases: noble house assaults, arson, raping a woman, or robbery on the public road. According to the end of 15th century bills, the criminal homicide suit was supposed to be filed in Starost court when the homicide was committed during noble's house assault. As we could remember, it was the death penalty that should be decreed as a result of such crime. Basing on the constitutions enacted at the turn of 16th and 17th centuries, Starost was authorized to adjudicate homicides committed during town's riots, and since 1611, when the Bill of Courts and Semi-Security was enacted, a lawsuit against the killer could be filed also to the Starost of his court. In the Old Polish legal system, the criminal trial was not an opposite of civil lawsuit. What is more, criminal procedure was based on civil one. As a result, principally a suit could be only initiated by a complaint brought by a plaintiff. So was it in homicide criminal cases. If it comes to homicide, that were the statutes of Casimir the Great, mid-14th century, which forbade ex officio trial commencement. The homicide lawsuit could be only brought by a claim of injured party, usually the relatives of the deceased. As I mentioned above, the competences of Starost was also primarily limited. The situation changed at the turn of 15th and 16th centuries. First, it was the mandatory public punishment, so in the imprisonment in tower. So in the bill in 1510, the ex officio trial commencement was introduced. Who was the center organ of new procedure was the Starost. It was obligatory for Starost to notify the monarch of homicides committed in his district, and as a result, the ruler could file a suit against the alleged murderer. Due to the inefficiency of above-mentioned proceedings, the system was reformed at the end of 16th century. The same did not leave the civil claim of his homicide behind. However, it introduced an auxiliary claim of Starost filed to the Crown Tribunal. It was the Starost who was authorized to bring the lawsuit if the relatives of deceased had not did it in the period of 1 year. I think I will skip to the another issues. If it comes to a particular part of trial, so the Inquisition, this is the quote from Jan Sforzowski project of Constitution in Criminalibus Scrutinio Precedente. He emphasized the role of scrutinium, so the inquisitorial phase of criminal case. To briefly describe what was scrutinium, it is necessary to stress that scrutinium did not mean strictly collecting evidence. It was rather witness examination conducted before the mere trial started. Sometimes the positive result of preceding scrutinium was a sine qua non condition for starting the lawsuit. The bill of mid-16th century authorized the Starost to carry out the scrutinium, and it should be conducted in the nearest court session following the date of committing the crime. It was plaintiff who was able to initialize such examination. Each party was enabled to bring no more than 12 witnesses. The testimonies given during such questioning could prove the innocence of the defendant, and as a result, the trial did not even commence. And the last part, so actually the Starost was the main organ of execution in Old Polish law, execution of court sentences. Usually the convicted noblemen were reluctant to serve over a year of imprisonment, so as a result they often refused to appear in the place of isolation, or even they escaped. Such approach since the end of 15th century led to ipso facto infamy. That was a kind of punishment that did not require any legal proceedings or a decree. The escapee was legally considered infamous. They were called infamies in Polish, and being banished could be killed with impunity. At the turn of 16th and 17th centuries, there was a particular procedure of proclaiming such individual infamous. They were starosts who filed a suit to Starost court, so judicium castrense, in order to declare the escapees infamous. Starosts were also legally responsible for seeking and punishing such individuals. Runaways, because of the penalties avoidance, was de facto sentenced to death without any legal case. As the basic penalty for homicide was the penaturis, so the imprisonment, the issue of aforementioned towers needs a brief discussion. Such towers were usually located in castles, which were the seat of the starost. In principle, the castles were situated in major towns in districts. So it were starosts who were responsible for their maintenance. They should have also supervised the imprisoned. As I mentioned before, it's particularly necessary to serve the time of the imprisonment in fundo, so in the bottom of the tower, and starost could not let the imprisoned, starost could not let the imprisoned have stoves or serve the penalty in the upper part of the tower. The plaintiff in the homicide trial could supervise the starost whether he carried out his duties properly. And to sum up, if it comes to the situation at the break of 16th and 17th centuries, the main penalties for homicide was the tower penalty, so the imprisonment and the compensation. Sometimes it was the death penalty. In particular cases, Starost played a major role in homicide cases in this time. Sometimes he was also a competent court. He was granted an auxiliary claim if relatives were passive, and he conducted scrutinium, sought the Inquisition, and also kept a register book. Of course, he was responsible for maintenance of tower and execution of court decisions. Thank you.